Hey guys, Shalom Schlagman here, and I'm going to take you on a really quick history of the legal cases involving informed consent in pediatrics. Now, of course, there are dozens and dozens of cases, so we're just going to look at a few, and this is going to be our basic outline. We're going to first look at the origin of informed consent at the bedside. We're going to look at the sources for the reason that parents are allowed to consent on behalf of their children. Then we're going to look at cases that lead us towards exceptions to that rule that parents get to consent on behalf of their children. And finally, we're going to end with a contemporary case, the case of Cassandra C. So the origin of informed consent. It all goes back, as I'm sure many of you are aware, to Schlondorf v. New York Hospital. Now, Mary Schlondorf, back in 1908, went into New York Hospital because she was having stomach issues. And she and her doctors negotiated an agreement. They thought that she might have a mass in her pelvis, and they negotiated that they were going to do an exploratory laparotomy, but she made it absolutely clear that she did not want them to remove anything from her abdomen. They open her up under ether, they find a fibrin tumor in her uterus, and they remove it, even though she had told them not to. She wakes up to find out what they had done, eventually develops gangrene and loses several fingers, so she sues the hospital. But she loses in the trial court, and there it's decided that because she was receiving charity care, she didn't have any standing or any grounds to sue for negligence. So she, of course, appeals, and the case goes all the way up to the highest court of New York State, and there Justice Cardozo completely disagrees with the lower court's findings. He ends up saying that in the case at hand, the wrong complained of is not merely negligence, it is trespass. Every human being of adult years and sound mind has the right to determine what shall be done with his own body, and a surgeon who performs an operation without his patient's consent commits an assault for which he is liable in damages. Justice Cardozo has done an incredible thing. Previously, the legal concern when it came to medical malpractice was only negligence. And this meant that by default, doctors ought to do more, because if they were going to be sued, it was going to be for having been negligent in a patient's case. Justice Cardozo is saying there's another concern, and that is trespass and assault. If you in any way invade a person without his consent, then you have assaulted him and trespassed upon his person and his property. And so now there's a balance between being negligent and not acting, and acting without the patient's consent. And what's interesting is that he writes that it's every human being of adult years and sound mind. So he qualifies it in two ways. They have to be able to really think about what's going on, and they have to be an adult. And so that brings us, of course, to our case, which is the question of what do we do with children? And so we know that parents consent on behalf of the children, so the question is why? Where did that come from? And it turns out there are actually two different cases with two completely different views on the matter. So back in 1941, there was a young man named John Bonner, and he was 15 years old when he underwent an operation to remove skin to donate to his cousin, who, according to the court documents, and I quote here, was a hopeless cripple. Of course, we wouldn't say it that way today, but that's the situation was that she had been really badly burned and she needed a skin graft. Her cousin underwent the skin graft at age 15 to help her. His parents actually didn't know about it. He had been brought to the hospital by an aunt who was not the girl's mother. It was a mutual aunt of both of theirs. And he had some pretty bad complications and ended up being in the hospital for 2 months. So his family sued the hospital. And the U.S. Court of Appeals, as the case rose up it hit the U.S. Court of Appeals, and the Court of Appeals, in their decision, Chief Justice Groner, he writes that even though there are situations in which minors are able to enter into consensual obligations and are able to consent to invasions of property or person, he writes that in deference to common experience, there is a general recognition of the fact that many persons, by reason of their youth, are incapable of intelligent decision, as a result of which public policy demands legal protection for their personal as well as their property rights. So he writes that the reason that children should not be able to consent in situations like this is that they are not capable of making intelligent decisions, and therefore they are part of a protected class, and that adults need to make the decisions for them. And he finishes off by saying, it is not at all surprising that generally speaking the rule has been considered to be that a surgeon has no legal right to operate upon a child without the consent of the parents or guardian. And the reason, of course, is that the parents and guardians are acting to protect the child who is not capable of making the decision. Now, that is a totally different way of looking at it than what we get from the case of Lacey v. Laird. Now, Lacey v. Laird is a fascinating case because in this case, Martha Lacey, who is 18 years old, had gotten rhinoplasty from Dr. Laird. And when the case reaches up to the Ohio Supreme Court, back then, age 21 was the age of maturity, and at 18, Martha was completely still a minor. And one of the arguments that the family makes is that she should not have been able to consent on her own to that operation, and the parents should have been the only ones to be able to consent. And Justice Hart, in his decision, this is a fascinating case because it was resolved in favor of the family in the trial court. The doctor appealed. In the appellate court, it was resolved in favor of the doctor. The family appealed up to the Supreme Court, and all of the Supreme Court justices find in favor of the doctor, and they agree with the appellate court, but many of them have different reasons, and so they write different concurring decisions that actually really contradict each other in fundamental principles, just end up at the same result that Dr. Laird wins the case. So we're going to actually look at a different concurring decision from the same case when we come to a different part of this discussion, but here we look at Justice Hart's concurring decision. And he writes that the general rule seems to be that a surgeon who performs an operation upon a minor without consent of his parents or guardian is guilty of trespass and battery. Why? And here is his reason. This rule is not based upon the capacity of a minor consent. It is, so far as he is personally concerned, within the field of the law of torts or the law of crimes, but is based upon the right of parents whose liability for support and maintenance of their child may be greatly increased by an unfavorable result. Meaning, it has nothing to do with the fact that children are incapable or capable of making the decision. Even if the child was 100% capable of making the decision based on his own intelligence and maturity, it would still be up to the parents' consent. Why? Because the parents have full financial responsibility and liability for the outcomes. Therefore, it is their property interest that is at stake in the child's person. Again, the child's person represents a property interest of the parents because they are liable for anything that comes out of this. So, you might wonder if Justice Hart wrote that, only the parents get to decide, and he's very, very clear that only the parents should be able to consent, how it's possible that he found in favor of Dr. Laird. Basically, it was because the trial court did not explain to the jury appropriately, in his eyes, what nominal damages were, and they made it far too open, and therefore the family could have been awarded far too much money under nominal damages, and he thought that that was a prejudicial error, and therefore found in favor of Dr. Laird based on that argument, and not because Martha Lacey should have been able to consent to the procedure. So even though she couldn't consent, and Dr. Laird really did commit assault and battery, Justice Hart still finds in his favor because of a procedural error. Okay, so again, just to review, two understandings of why parents decide on behalf of their children. The first came out of Bonner v. Moran, and that's because children are a protected class because they are not completely cognitively developed, and they have to be protected by adults. The other understanding comes from Justice Hart's decision in Lacey v. Laird, and that is that children are decided for by their parents or guardians because those parents and guardians are financially responsible for the child, and it really doesn't matter if the child is capable of making the decision based on his own cognitive development. It only matters that the parents have financial liability based on the results of the decision. Okay, so now that we understand why parents get to decide for their children, let's think about cases in which they do not get to decide for their children. And these can be broken down into two different categories. The first is situations in which a child gains the right to choose and the parent does not get to choose, and that's when you have an emancipated minor or a mature minor. And the next two cases are ones in which the doctor or the state gains the right to choose, and that is when you have an emergency situation or the state acting as parens patriae. And now these 4 exceptions, we're going to look at really quick cases to explain them all, but the 2 that are the most important to our discussion are that of the mature minor and the state acting as parens patriae. Okay? So really quickly, the case of the emancipated minor, that one's pretty obvious because, and I'm not going to read the decision to you, I'll just tell you really quickly, this involved a young man who was 18 years old. Once again, 21 was the age of maturity. He was a father, he was a husband, he had his own job, but he also had a chronic illness, and in that situation, he underwent a vasectomy because he believed that it would be a burden on his wife if they had more children, given that he was chronically ill. When he turned 21 and was now a full-fledged adult, he sued the doctor saying that he shouldn't have been able to consent to the procedure and his parents ought to have been considered. The court, the Washington State Supreme Court, finds in favor of the doctor and basically says that because this guy was finished with high school and therefore his cognitive development was at least finished to the point of what we expect adults to a baseline for what adults should be, and because he was financially independent and the head of his own household, there was no reason that he shouldn't be allowed to decide for himself. And that actually makes sense because it answers the concerns of both Lacey versus Laird and Justice Hart's concerns that a minor is not financially responsible for himself, because obviously an emancipated minor is, and it also answers the concerns of Bonner v. Moran, which is that the person needs to be cognitively developed enough to make the decision. And here the court argues, well, we see that he is, and that's one of the things that you would evaluate when evaluating an emancipated minor. So you can read about it more if you'd like. The case of the mature minor is also incredibly interesting, and part of this actually comes from the Lacey v. Laird case. Again, the case of Martha Lacey, who was operated on, her nose was operated on by Dr. Laird, and she was 18 years old, which was at that time not considered to be a full adult. And here, Justice Taft, who also found in favor of Dr. Laird, he has a completely different reason, and his reason is that as an 18-year-old, Martha Lacey was perfectly capable of making her own decisions and was capable of consenting in a very real and legal way. And his argument is based in 2 parts. Number 1 is that when it comes to criminal law and the law of torts, the law of damages, children have a progression from 0 to 21 at which they gain legal responsibility for their actions. And that between ages 7 and 14, even though the default position is that a child between ages of 7 and 14 cannot be considered a criminal when they commit an act that would be a crime, if we can prove that they really had the capacity to understand what they were doing and the consequences of their actions, then they can be prosecuted even in a capital offense. And not only that, but after the age of 14, the default position is that the child is prosecuted, and just like an adult. And therefore, even though they aren't adults, the child can be thought of in certain ways as an adult and loses, as he says, any special immunity or presumption of incapacity. And he goes on to argue that, of course, Martha Lacey was 18, so she was in that category between 14 and 20. There's no reason she should not have been able to consent, and he even says that if you look at the state law when it comes to rape for children, a 16-year-old girl is allowed to consent to sex, and consensual sex makes that not rape, and if her consent takes the situation and makes it from one of crime to one of consensual, non-criminal activity, then that should be exactly the same when it comes to assault and battery in medical situations. That an 18-year-old girl should be able to consent to a medical procedure. Now, he never actually uses the idea of a mature minor. He's using a very technical legal analysis and arguing that if we are able to compartmentalize childhood into smaller parts, break it down and think about different stages of development, then children gain both rights and responsibilities when it comes to being able to act and consent in specific legal situations. The terminology and source for the idea of the actual mature minor comes from the case of Belcher v. Charleston Area Medical Center, and that is the case, an incredibly sad case of Larry Belcher Jr. He was a young man who had muscular dystrophy. When he was 17, he was hospitalized because he had a cold, and because of his weakness was not able to expel mucus and choked. He was hospitalized and intubated, and although he was temporarily extubated in the hospital, his physicians discussed with his parents the fact that he really would never be able to be successfully extubated in the long term, would probably very soon require a tracheotomy and feeding tube just to support his airway. And his parents obviously had a very difficult decision in front of them, and they, while Larry was extubated, decided to make him DNI and DNR. And the very next day, on December 24th, 1986, Larry Belcher Jr. passed away. He choked again, he was not intubated, he was not resuscitated, and he died. His parents were distraught. They end up suing both the hospital and the attending physician, Dr. Ayubi. And one of their arguments that they make is that Larry, as a 17-year-old, who now in the 1980s, 18 is the age of majority, so he is basically almost an adult, he should have been consulted. His consent really should have been necessary in making this decision, this really ultimate decision about his treatment. And the court, when it reaches the original trial court, basically throws out that argument because the doctors say that because he had had lifelong illness, was not mature. And the court never considers the fact of whether or not he was mature because the doctors basically say he wasn't. But the parents appealed the decision, and it makes it all the way up to the West Virginia Supreme Court. And the Supreme Court ends up sending it back to the lower court, arguing that they made a mistake in not assessing whether Larry was a mature minor. And they say that it's true that children are usually decided for by their parents, but that is only true when the child is young and not yet mature. But when the child is a mature minor, then the child's consent would be required. They say that whether a child is a mature minor is a question of fact. Whether the child has the capacity to consent depends upon the age, ability, experience, education, training, and degree of maturity or judgment obtained by the child, as well as upon the conduct and demeanor of the child at the time of the procedure or treatment. The factual determination would also involve whether the minor has the capacity to appreciate the nature, risks, and consequences of the medical procedure to be performed, or the treatment to be administered or withheld. They argue that there is such a thing as a mature minor doctrine, that it's determined on a case-by-case basis based on a plethora of qualities that the child may have or may not have attained, and also based on the specific ability to understand the procedure and its risks and benefits. The court sends the case back to the lower court and tells them that they have to now consider whether Larry is a mature minor, and from here we get the idea that the mature minor is able to consent. It has nothing to do with his financial responsibility for himself. So when we go back to the original two ideas of why parents are allowed to consent, so in the case of Bonner v. Moran, it had completely to do with the child's capacity for decision-making and the fact that parents had to step in to protect a group of people who were unable to really make decisions for themselves. And here it's very clear, according to the West Virginia court, that that should be decided on a case-by-case basis. Some children are not capable, and their parents or somebody has to step in and make the decision for them. But when the child is capable, he should or she should be allowed to make the decision on his or her own behalf. And by not addressing the issue of finances at all, they clearly reject the entire idea brought up by Justice Hart and Lacey v. Laird that the child's parents make the decision on his behalf because they are the ones financially responsible. In fact, the West Virginia Supreme Court goes so far as to say in the last line here, where there is a conflict between the intentions of one or both parents and the minor, the physician's good faith assessment of the minor's maturity level would immunize him or her from liability for failure to obtain parental consent, meaning that the physician cannot be sued by the parents if he sides with the child, if he made a good faith attempt to determine that the child was in fact mature enough to make that decision. That the child can make a decision when he's mature, even if it goes against the parents, and the parents are the ones financially responsible. And so this court has completely rejected, or at least ignored, Justice Hart's decision in Lacey v. Laird. So just quickly to go over the idea of the emergency, I mean, this is pretty obvious. It was even, we didn't mention it, but it was way back in Justice Cardozo's decision in Schlondorf v. New York Hospital, that in the case of an emergency, you don't have to wait for consent, you just act, and that's true for an adult, that's true for a child. And there are many cases about it. This is one I just happened to find. It's interesting if you go and look it up what the case specifically was. Now, the concept of parens patriae is a fascinating and important concept, and that is that the state has a vested interest in its children growing up to be productive citizens. And that goes back to the case of Betty Simmons, who was a 9-year-old who lived with her Aunt Sarah Prince, who was also her legal guardian. They were Jehovah's Witnesses, and they used to go door to door selling Watchtower magazine and proselytizing on behalf of Jehovah's Witnesses. And the state of Massachusetts told Sarah Prince that she was not allowed to take her niece door to door because it was a violation of child labor laws. Sarah Prince sued the state, arguing that she had a religious right to meet her religious obligations and have her niece do so as well. Now, of all the cases that we have seen, this is the only one that made its way all the way to the United States Supreme Court, and the court found in favor of the state, and there Justice Rutledge wrote, "Neither the rights of religion nor the rights of parenthood are beyond limitation. Acting to guard the general interest in youth's well-being, the state, as parens patriae, may restrict the parent's control by requiring school attendance, regulating or prohibiting the child's labor, and in many other ways. Its authority is not nullified merely because the parent grounds his claim to control the child's course of conduct on religion or conscience." Justice Rutledge clearly articulates that parents have the ability to guide their children's behavior and base those decisions on religion or any other moral source that they would like, yet they are not allowed to infringe on their children's well-being. And when they do so, the state may step in and prevent them from doing such. His case is particularly about a child who's being forced to work, but he expands it in his writing, saying that compulsory school attendance is part of the same law, and he even says, leaving it very wide open, quote, "In many other ways, the state may step in to prevent a parent from harming a child's well-being." Obviously, when it comes to healthcare and a child's not just physical well-being, but very life may be at stake, the state can step in and prevent the parent from harming the child or from withholding treatment from the child. And that brings us to the case of Cassandra C. You will all have read, if you haven't already, one of the articles in the news outlets about the case, so I'm not going to tell you all the details, just very quickly say that this is a 17-year-old who has Hodgkin's lymphoma. She is being forced to take treatment by the state, and the case went all the way up to the Connecticut Supreme Court. They ordered her to receive treatment on January 8th, 2015, and they wrote that she had the opportunity to prove to them that she was a mature minor, and she failed to do so, and therefore their forcing her to take treatment is not a violation of her right to due process. Interestingly, at least according to the Washington Post, an article that I saw there, the state of Connecticut does not actually endorse a mature minor doctrine, and the court is writing here that even though it's not clear in Connecticut law that she would even be able to make her own decisions as a mature minor, even so, she hasn't proven herself to be one, and so they don't even have to address that issue. So I look forward to discussing all the ethical implications with you of the case of the minor who is being asked to undergo medical treatment and who gets to consent, when the child does, when the parents do, how we decide, and it'll be a great discussion. I'll see you Wednesday.